Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I can answer your questions. Let me formally introduce myself. I am U.S. Immigration Attorney Sharifa Tharpe. I come on every night around 9 p.m. Eastern Time to take your immigration questions, and then also to touch on immigration topics that I think is important for you to know about. Mainly immigration topics that help people to understand ways that they can fix their immigration status if they ended up overstaying or crossing the border without permission. And so tonight, though, I am going to be talking about going from the 2-year green card to the 10-year green card because they have just issued a policy update stating that because of the length of time that it's taking to hand out the renewals from the 2-year to the 10-year green card, they are now extending their. So usually when you apply to renew from the 2-year to the 10-year green card, they will issue a letter acknowledging that you submitted your application, is being processed, and that will also contain your extension letter. The extension letter was for 18 months. Now they're extending it to 2 years just because the cases are backlogged. And so they're trying to extend that time for individuals to make it more convenient for them. So I just thought, along with that update, I can tell you about that process. So if you're going through that, or you know you're going to go through it, you will know what to expect. So hello, we filed for my sisters in 2010. Everything is processed and case is in NVC. How long until they can get the visa? So while you filed in 2010, it really depends on what date they're processing. Now, the cases are taking 14 years, a minimum of 14 years if you file today. However, I don't have the bulletin in front of me to tell you what date they're processing now. However, I can tell you how to get there. So if you do Google and you go find the National Visa Bulletin, you go there, you will be able to find the F4 category and the current date that they're processing. If your date is based on the date, so say the date they're processing is 2006, say June 2006. That's just an example. You have to go there to verify. Then you'll know based on that date, you have about 4 more years because it's 4 years ahead of you. So that is what you'll have to do. But I can tell you, if you filed your application today, it would take a minimum of 14 years because that is the processing time total. So keep your questions coming. I am here to answer your U.S. immigration related questions. So put your questions in the comments now. So I'm planning to move to UK. Do you handle UK applicants? So no, I'm a U.S. immigration attorney. So so you'll have to consult with a UK attorney. Thank you. Should I go to the NVC bulletin to look at the time? So yes, that would be your best bet. If you want to get a more accurate timeline for yourself based on the particular date that you filed, based on your priority date on your receipt notice, then you will have to go to the National Visa Bulletin, and that's where you will see the date. So keep your questions coming. I'm here to answer your U.S. immigration related questions. So put those questions in the comments. And can we track the case by receipt number? So with the receipt number, that is the USCIS. So if it's at the National Visa Center, that means it's waiting to be in process. Now, the sibling applications, once it's approved, it doesn't mean that it's going to go straight through to the embassy for the interview. There is a very long wait list. The wait list is 14 years long. And by the way, it depends on what country you're in. So for example, Mexico is taking 20 years. In the Caribbean, 14 years. In other countries, 19 years and 15 years. For example, in India, I believe it's 15 years. So it differs based on the country that you're living in, based on the and here, since you filed in 2010, that's where you're really gonna have to look to see, because I know if you file today, it's gonna be 14 years. And so to get a better idea of where you stand, you need to look at that. The receipt number, if you look at your priority date, that's going to be the most important thing to help you to determine how long of a wait you possibly have left. So 14 years to get what visa or green card. So it's called the F4 category, and this is where a U.S. citizen sibling who's 21 and up is applying for their sibling. So in that case, it's a minimum of 14 years and 14 years in the Caribbean, for example, Jamaica, but it differs from country to country. In Mexico, it's touching on 20 years if you filed your application today. Obviously, if you filed your application years ago, it's still a long wait, of course, but you have less of a wait. It's just dependent on your priority date that's in your receipt notice. Now, if you would like further guidance, you can definitely schedule a consultation, and I can walk you through your particular situation, advise you legally based on your circumstances. But you will have to look at your priority date, and that's going to give you an idea, and go to the National Visa Bulletin. If someone's B2 visa gets revoked, can he adjust his status through marriage? So it depends. So why did they get it revoked? And adjusting status means that they have to be in the United States. If their B2 has been revoked, usually when it gets revoked, that means that they are already outside of the country. And in that case, you would go through what's called consular processing. So if you did get married, it is possible for your U.S. citizen or resident spouse to petition for you to get the green card. However, whether you're going to be successful is going to depend on why was it revoked. What was the seriousness? Well, how serious were the immigration violations? Has it caused you to be inadmissible? And if you're inadmissible, how long must you stay outside of the United States before re-entry? That's going to tell me whether you qualify for a waiver, whether if the waiver is an option, how you need to qualify for that waiver. So as you can see, it can get a little more complex just depending on the circumstances. And that's where it's very important to schedule a consultation to get professional and personal guidance through your process, because all the information that I'm giving you here tonight is general information. It's not personal legal advice. How long is I-130 form is taking now for parents filing for kids over 21? So this also takes a long time. So it depends. If your parent is a permanent resident, you're looking at 5 to 6 years. Keep in mind that child that's 21 or over has to be unmarried. If it's a U.S. citizen filing for an unmarried child, 21 or over, that's taking 6 to 7 years. So it's still taking a long time. Now, if you are a married son or daughter over 21, then that is taking around 12 years. So it is a long wait time. And yes, I do see someone is laughing, and I think it's because of how frustratingly long these wait times are, which is crazy. And so, yes, it's impossibly long, but these are the wait times that you have to deal with right now. Razan Nakvi, you're welcome. So Dangles, Trinidad. So with Trinidad, it's about the same. So 14 years. What if my fiance has citizenship? So if your fiance has citizenship, then there is the option of the K1 or fiance visa. Now, only U.S. citizens can actually sponsor their fiance to come here on what's called, it's another name for it, is a 90-day visa. And you come here and you have 90 days, all being well and it's approved. You have 90 days to come to the U.S. and then get married. And then you can adjust status to permanent residence once you get married. So that could be an option. Now, to qualify for the K1, you'll have to, one, be able to show that you have met your fiance in person within the last 2 recent years, the 2 recent years before applying. And then you have to show that, yes, this is bona fide. You do have every intention to get married. So if a spouse filed for immigration visa but refused to file an affidavit of support, is there a workaround? So Al-Qaeda, it depends. I don't know what the situation is, but that your spouse should be prepared to go through the entire process, which includes the affidavit of support. Nobody can force the spouse to provide the affidavit of support. Now, if this is something that your spouse is doing to sabotage your process, then that may indicate that there is a larger problem going on here. And so my next question to you is there mistreatment going on in your marriage? Is your spouse, do you have a feeling that your spouse is trying to sabotage your immigration process for some reason? If that's the case, you should really explore your options in a consultation, and we can talk more about the circumstances in your marriage, and should you qualify, there may be a way for you to apply on your own based on mistreatment, but I have to evaluate your case in full to determine whether it fits the criteria to apply for this. And you have to also make that decision if that is what you want to do. However, in a case like that, it does not require you to submit an affidavit of support. And while I wouldn't say that you should take, this is not anything that you would file just because your spouse refuses to file an affidavit of support. There has to be something more going on, like your spouse is mistreating you, there's abuse in the relationship. However, if your spouse is not going through the entire process with you, I would definitely question why and figure out if there's a bigger problem that you need to solve. If you're on file for green card, how do it take before you get the call? So it really depends on who is sponsoring you, what's your age, what's the status of the person that's applying for you. What's your relationship with that person that's applying for you? Because the times are going to range. Now, if you're the immediate relative of a U.S. citizen, hi there, Cheryl Curtis. Thanks so much for saying hi. Al-Qaeda, you're welcome. Now, if you are the immediate relative of a U.S. citizen, that means you're the spouse of a U.S. citizen, you're the parent of a U.S. citizen who's 21 and up, or you're the son or daughter of a U.S. citizen who's under 21 and unmarried, then that is the fastest process within the family immigration process, within the immigration process, actually. Because, thanks so much for the rose, because it takes about 18 to 24 months. It used to be shorter pre-COVID. However, with the Trump administration's policy changes and then COVID, it really made the wait times longer. We're hoping they'll clear that up soon. However, 18 to 24 months. Anything else, you're looking at years. So 5 to 6 years for green card holder parents sponsoring their son or daughter 21 and up. U.S. citizens sponsoring their children 21 and up, and unmarried 6 to 7 years. Married children of U.S. citizens 12 years. Siblings of U.S. citizens who are 21 and up 14 years at minimum. Mexico, it's 20 years right now. So as you can see, the times, the wait times change just depending on what is your relationship in that process. My grandmother filed in 2008. We got called in 2019 saying it was approved, still waiting. So in your case, Narisa, as I had listed before, it's really based on, it sounds like you would be the son or daughter of of the person that's being sponsored, because grandparents can't sponsor their grandchildren directly. The children who are under 21 and unmarried can go along with the parent that's being sponsored by their parent, the grandparent. And so what I would advise you, you want to make sure that if you got called and it has been approved, and if they are now it's at the National Visa Center, they're ready to process your case, and they've been exchanging documents with you, then that means that they are preparing you for the interview. I know you may still be waiting at this point just because everything is slow, COVID, shutdowns, and so everybody has been waiting for their interviews right now. You're not alone in that case. However, if the National Visa Center isn't currently processing your case, and it's just sitting at the National Visa Center, that means that your immigrant visa number probably hasn't been available yet. What you'll need to do, so still waiting on a call for the interview, we've sent in all the required documents. So Narisa, that's right. So in this case, you're not alone. Many individuals are waiting just because the COVID, Trump administration policy changes have really pushed back a lot of people's cases. And so just hang tight, make sure you keep a watch on your case. And also make sure that you understand the aging out process. So if you're still under 21 and unmarried, then you should be okay. But once you reach 21, you'll want to make sure that you can still go through that process. And there's a special formula that the officers use to determine whether you can still go along with your parents. My mother, she is an American citizen. So Sherry Weeks, let me see okay, so she is an American citizen. So if you file today, it's taking 6 to 7 years. However, I don't know where you are in the process right now, Cherry Weeks, but it would be 6 to 7 years if you're unmarried and 12 years if you're married. Narisa, I'm glad you understand. Anointed Child 7, thanks so much for sharing the live. My sister is a teacher. Is it easier for me to apply for her, or should she go through an employer? So it depends on your sister. So if your sister has a prospective employer, then for sure she could definitely pursue that option. I know as a U.S. citizen sibling, it's still going to take a while. So if you file for her today, it would take about 14 years right now if she's in Jamaica, for example, or in the Caribbean. If she's in other countries, it could take longer. And so it's really going to depend which way your sister should go. It's going to depend on her particular circumstances, where she is, and whether she has an employer in the first place. So keep those questions coming. I am here to answer your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. So I have been talking, also I brought the topic going from a 2-year green card to a 10-year green card. What does that look like? I already talked to you about the fact that you should I already talked to you about the immigration update, that they have just announced that when you apply for the 2-year green card to renew to the 10-year green card, they're now issuing 2-year extension letters. That means that as long as you have this extension letter, you can carry it around as evidence that you continue to be a permanent resident while your process is pending. The reason that they've changed it from 18-month extension letters to now 2-year extension letters is because the processing times are taking so long that they want to make sure that they try to accommodate you as much as they can. So keep those questions coming. I'm here to answer your U.S. immigration related questions. So put your questions in the comments and I will answer your questions. So let me continue. As your questions come in, let me continue with this topic. So applying, what is a 2-year green card? What is that 2-year green card? They also refer to it as the conditional green card or conditional permanent resident. So I'm going to talk about the marriage-based conditional resident. Now, in this case, if you marry a spouse who sponsors you for your permanent residence, that could be a U.S. citizen or a permanent resident, then what will happen is that you will apply, if you are married for less than 2 years at the time that you are approved for the immigrant visa or the permanent residence during adjustment of status, you will get a 2-year green card. So if married less than 2 years at the time of approval, you get the 2-year green card. And it's kind of a probationary period where they want to make sure that you apply to go from a 2-year to a 10-year. They call it the removal of the conditions in 2 years. So you have to apply usually 90 days before your card expires. And you have to file jointly with your spouse. And the reason I call it a sort of probationary period is because they want to make sure that the 2 years following your getting your green card, you still maintain a great a marriage, not necessarily great, but that you have maintained your marriage. It is real. You continue to build a life together. They want to be sure that that's the case and that you did not marry just for the permanent resident. And so at the 90-day mark, the 90 days before your 2-year green card expires, it is required that you jointly file with your spouse. That means that your spouse has also signed what's called the I-751 form to renew that 2-year, remove the condition from your 2-year and turn it into a 10-year. Now, there are situations where you can't file with your spouse, and I'll get into that as well. There are ways around that. There are ways to still go ahead and apply on your own under certain circumstances. But let's describe how important it is first. I want to talk about how important it is to timely file your application with your spouse. So if you are with your spouse still, you are able to file jointly with your spouse, it is very important that you submit a timely application, because it has to be filed within the 90-day period before the card expires. If you don't, then if it's late, they will deny it unless you have a good reason, usually exceptional circumstances that justified the late filing. So for example, if you experience a death or an illness, or you were in the middle of having a baby and you could not file your application, those could be good reasons why you didn't timely file it. But who wants to go through that? Who wants to have to submit additional paperwork to prove why you didn't meet the deadline to file for this application? So one, it is very important for you and your spouse to file jointly within the 90 days before that conditional residence expires. However, if you miss it, don't give up hope. Don't think that all is lost. If you have a good explanation, that still is possible. So if a licensed realtor in Cali gets married to her spouse who lives in Florida, would that be a problem? Will immigration find out I have active real estate license in another state? So Kerry, real estate SD is definitely that is not something hard to find at all, and they do look at those things. And so they will approach your situation with a lot more skepticism if they feel like you are living apart, especially if you don't disclose that. If you don't disclose it, they will find it, and that can have a harsher consequences on you and your spouse. You could be accused of marriage fraud if you try to hide if you try to hide the fact that you're living apart or that you are working in California as a realtor. They will find that. I mean, I probably can Google that and find you. So, and they have found things that are harder than that to find. So definitely you have to be straightforward. Give the valid reasons why you're living apart. But what I would say is that if you're not living together, they're definitely going to have questions about that. And you have to definitely show some good evidence to overcome the fact that you're not living together. Because officers see these kinds of arrangements all the time, and their first instinct is to think this is marriage fraud, unless you can prove otherwise, unless you can show some sort of evidence to overcome that suspicion. But one thing I can tell you is don't try to conceal anything, don't misrepresent any facts, because that can lead to even worse consequences. And they do look at public records, they do look at your background, they have that information in front of you, and they'll definitely ask you at the interview. If you are married a U.S. citizen, send your application in like what you do most. So I'm not understanding that user 584. Can you rephrase that? So planning on getting licensed in Florida too, would that be okay? So Kerry Real Estate SD, when you work, so if say you are a realtor in California, you're licensed there, if you're living in Florida with your spouse, but you still, you move back and forth, you work remotely maybe, then that should be fine. And where you work, what you're doing, that's not necessarily the problem. Like, what you need to be concerned about is the fact of where you live, how you're living with your spouse, and how to explain that. But there are no limits on what you can do professionally. It's just that you have to make sure that you are upfront, you're honest, and you have good evidence and explanations about the marriage and the bona fides of the marriage. Married filing separately, can it affect when you're filing for citizenship? So while taxes aren't required to show that you have a bona fide marriage, it's definitely something that can be good evidence. So if you it's really up to you and what's best for you and your tax planning, right? And so what you need to make sure is that if you don't have your taxes to show, you're filing separately. One, you want to make sure you can explain in a logical way why that is the case. And then the other, if the officer asks, and the other thing is to shore up your other evidence to show that you are married. Now, I notice here that you're talking about when filing for citizenship. Now, married filing separately based on a citizenship application, whether that's going to affect it or not is really going to depend on who are you applying for citizenship based on your U.S. citizen spouse. In that case, it can definitely play a role. It's not a requirement, but it may play a role. There may be questions about that. However, if you are already a permanent resident and you've been that for 5 years, then you can apply based on your own merit. Now, if you have any concerns outside of the general information you've given me and I've given you, schedule a consultation. I urge you to do that so we can talk more about your particular circumstances, kind of hone into why you are concerned about the married filing separately, because there may be something here that you can't say here that you're concerned about that you can tell me in a personal consultation. So think about that. Call. Now, the way that you can schedule a consultation is by going to the link in my bio. There's a button for the website. Go there. There's a phone number. My phone line is 24/7. There's also an online contact form that you can complete. Can you repeat the answer to my question? Jen Neal, I don't remember what your question is. Can you retype? I'm moving forward trying to get to everybody's question. So can you retype so I can see your question again? If my family and I want to migrate to the United States, how can we become U.S. citizens? So you'll first have to become permanent residents. In order to become permanent residents, you'll have to qualify through an employer, through family, through even the diversity lottery. If you are the citizen of a country that qualifies for the diversity lottery, that's like the lottery for the green card. So it all depends on your circumstances and how you're getting the permanent residence, also referred to as the green card. Now, once you become permanent resident, you'll have to have it for usually 5 years to be able. If you get it through marriage to a U.S. citizen or you're married to a U.S. citizen, then it's 3 years. My aunt has overstayed. What can she do? So NAN 825, the solution is going to depend on what her circumstances are. The number one so it depends. Now, one way to fix your status is through family relationships. So if your aunt overstayed, does she have a U.S. citizen or legal permanent resident spouse or parent? If she does, then the waiver might be available to her. Also, if she's married and her spouse or her, if she's under 25, then her parents, or if she has a citizen son or daughter who's 21 and up, that could be a way for her to apply if those relatives are mistreating her. Also, there are other things that she may qualify for, just depending on her particular circumstances. That's why while you've given me general information, I have to tell you that there are ways. However, it's going to really depend on what's going on with her. And that could take a whole hour in itself to talk to your aunt about that. And so that's where the consultation is very important, especially if she doesn't know where to start or what her options are. My hubby is a permanent resident, but we're looking to bring his family here. What best was the start? So does his family qualify? Now, if he's a permanent resident, he can't apply for siblings. He can't apply for parents. He can only apply for a spouse, which you're already the spouse, or children. So either sons or daughters 21 and up, or a child who's under 21 and unmarried. Now, that would be the start. That is where you have to start, is who qualifies through your permanent resident. One thing I would say is that it's a good time to be sponsored by your permanent resident spouse, or to be the child of a permanent resident. Because right now there's no wait list for an immigrant visa number, which means that it is taking a little faster than normal to be processed. Thanks so much for the follow. I appreciate it. Will it pose a problem to apply for U.S. citizenship after 28 years as a permanent resident? So my instinct would be no. However, do you have any concerns? That would be my follow-up question. And if you have concerns, that's where you have to make sure that you do a consultation. And how long is he supposed to wait for a response from the USCIS? So let's see. I am a citizen, but he's a permanent resident, and he's waiting on his renewal green card. Waiting, and how long is he supposed to wait for a response? So Nathlia 156, it's going to depend on what's going on right now. Where's his case? What's been going on? What is the processing time for that particular service center that's processing his case? Right now, the average time is about 18 months to 24 months for these processes. If you have a warrant in NY and you live abroad, would you get arrested if you go back to try to fix it? So that may be more of a criminal criminal issue than an immigration issue. I get mistreat from my wife in overstay, and she doesn't want to apply for me. What I have to do? So user 584, that's where you schedule a consultation. Can't stress that enough. Your wife is mistreating you. She is, if that is the case, you can get help. There are options. So it's called the VAWA application, where you can apply for your own permanent residence. It's confidential. You can apply for your work permit in the meantime, and adjust status. Stay in the United States even though you overstayed. So call me. Let's do a consultation to confirm you qualify first, and then I can definitely help you through the process and get you going. Thanks so much for the follow and the shares. I appreciate it. How can I apply for my green card? I only have my US visa. So if you there is no automatic way to go from a US visa to your green card. You'll have to qualify through some means. My dad is a permanent resident, and I want him to file for me and my 2 kids. Is that possible? So if you're unmarried, then yes, your permanent resident father can. It would take about 5 to 6 years. Now, I am going to head over to Instagram. I have a pre-scheduled live that is usually scheduled for 9:30. I did spend a little time here, but our conversation doesn't have to end here. What you can do is head over to Instagram, and we can continue the conversation over there. So if I haven't gotten to your question, you can go to the link in my bio, click on the Instagram button, and it's going to take you to Instagram, where you can ask your questions. It is the immigration attorney, same as here. So it's the immigration attorney, or you can go to the link in my bio and click the Instagram button. So unfortunately, I'm not a I'm not a Canadian immigration attorney. I am a US immigration attorney. So you'll have to seek out a Canadian immigration attorney. So I am going to hop on over to Instagram. If I don't see you on Instagram, if you can't join me on Instagram, guess what? I'll be back tomorrow at 9 p.m. Eastern time to take your questions, and also to talk about a particular topic with you. So I hope to see you. For those of you who know you'll need a consultation, go ahead and call the number. You can go to the link in my bio. It'll take you to the website where you see the phone number. You'll see a contact form. You can go ahead, call or submit your information, and a scheduling coordinator will get back to you and schedule that consultation. Have a good night. I'll see you tomorrow here at 9 p.m. Eastern time. Or I'll see you on Instagram in a minute. Bye.